The goal of the 72 Act was very clearly to avoid pollution havens. Upstream states didn't want to be in a position where downstream states could outdo them or attract business on grounds that they wouldn't have to clean up as much as in other places. States clearly said to the Congress, the House, the Senate, we want a baseline, consistent federal standard so that industry could not be enticed from one state to a laissez-faire state. And that is largely what prevailed over the ensuing 30 years. Now we have a regulatory miasma. It wasn't created by the Congress, but it's our duty to clarify it. We need to look back at the fundamental principles of the Clean Water Act and its predecessor legislation to reaffirm the partnership between the federal government and the states to restore and maintain the integrity of the nation's waters, and to proceed to continue with the central thrust of the Clean Water Act, a watershed approach to establishing and maintaining clean water. A central fact of the central purpose of the Clean Water Act was control of point sources, and then establishing a basis for dealing with non-point sources, which was to be done in time, and to provide federal financial support to the states to carry out their end of the bargain. And the legislation recognized very distinct categories of unique activities. Agricultural return flows in the 72 Act. Agricultural return flows exempted. Stormwater runoff from oil, gas, and mining exempted. Maintenance of structures such as dikes, dams, levees, riprap, breakwaters, causeways, transportation structures exempted. Construction or maintenance of farm or stock ponds and irrigation districts. Again, clear consensus exemption. Construction of temporary sedimentation basins exempted. Moving of mining equipment. Construction or maintenance of farm roads and forest roads or temporary roads for mining equipment also exempted. And activities where states have an approved program to manage. All those were part and parcel of the 72 Act, which now are put in question by the Supreme Court decision. Over the last 7 years, I have laid on the table a proposal to address this regulatory uncertainty and chaos by what I consider to be misguided Supreme Court decisions. And after years of no action and no consideration, we had a major hearing. We've launched a major debate nationally and also and discussion within the committee on the proposal I've set forward. The goal of the legislative proposal is to restore the Clean Water Act protections in place prior to the Supreme Court decision, and not to extend the reach, not to go beyond that purpose. The pre-Swank case regulatory and Rapinos regulatory era defined the universe of the Clean Water Act very broadly to allow EPA and the Corps of Engineers and the states to address the water quality concerns where they found them, and worked relatively well for over 30 years. Now, implementation has also needed streamlining. There's no question about that. To the extent we can simplify practices, streamline permitting process, we ought to attempt to do that. And I welcome recommendations. Previous practice also was backed by science, viewing the natural water environment as interconnected. And that is a matter that needs to be continued. Stressing the role of protecting geographically isolated, intermittent, some cases called ephemeral headwater streams to protect total water quality. It's a common sense approach. It's cost effective. And it is practical, in a practical sense, effective in protecting pollutants from entering a water body, and much more efficient than trying to remove them once they go downstream. My legislation was not intended to ignite old debates that existed 35 years ago and that were resolved with the Clean Water Act, but to put the legislation, put the Clean Water Act back on the track that it was on a consistent basis prior to these two court decisions. Now, we had a previous hearing which we received a wide range of views. The purpose of today's hearing is to continue to receive specific recommendations from a wide range of affected and interested parties on how to proceed in the post-Swamp-Rapanos era and what specific adjustments they recommend to the introduced bill. I invite constructive proposals and remain open to adaptations to this bill. And I look forward to working with Mr. Micah and Mr. Bozeman, along with the members on our side of the aisle, on constructive proposals to make these adaptations. I reaffirm that the introduced bill is not an inflexible document, but a starting point for discussion. And I look forward to today's hearing, and now recognize our distinguished gentleman from Florida, Ranking Member Mr. Micah.
Well, thank you,